Okay, let's do civil law. Okay, let's begin. Again, please do read our disclaimer. Okay na yan. Okay, let's begin. In 2015, Amanda initiated legal proceedings in a Philippine trial court seeking judicial recognition of her foreign divorce. She claimed that she had married Lufio in 1993, and in 2007, both parties jointly filed for divorce in the City Hall of Sakado City, Saitama Prefecture, Japan. Following the acceptance of their divorce, Amanda sought recognition of the dissolution in the Philippines. During the evidentiary phase of the proceedings, several documents were submitted as evidence, including first, an acceptance certificate issued by the mayor of Sakado City, Saitama Prefecture, Japan. Second, an authenticated document from the Vice Consul of the Philippine Embassy in Tokyo, Japan, a photocopy of the Civil Code of Japan in English text. Notably, the Republic, represented by the Office of the Solicitor General, did not raise objections to the presentation and admission of this evidence, explicitly stating that they would not present any opposing evidence. Amanda relied on the acceptance certificate to substantiate her claim that the divorce had taken place. In contrast, the Republic contested the validity of the acceptance certificate, asserting that the foreign judgment itself should have been presented as evidence. Is Amanda entitled to judicial recognition of foreign divorce? Based on the case of Republic versus Kikuchi, the answer is no. Amanda is not entitled to the judicial recognition of foreign divorce because she failed to present evidence to prove that the existing law on divorce in Japan. Again, no, Amanda is not entitled to the judicial recognition of foreign divorce because she failed to present evidence to prove the existing law on divorce in Japan. The Supreme Court held that the submission of the photocopy of the English translation of the foreign law does not constitute sufficient compliance with the rules on proof of the foreign country's laws on divorce not being an official translation. The document submitted by Amanda does not prove the existing law on divorce in Japan. Unfortunately, without such evidence, there is nothing on record to establish that the divorce between Amanda and Lufio was validly obtained and is consistent with the Japanese law on divorce. Again, based on the case of Republic versus Kikuchi. Second question. In October 1996, Bebeco and Haneko, who were employed as factory workers at separate electronic companies in Taiwan, began dating shortly after their introduction. Despite Bebeco's disclosure over past traumatic relationships, Haneko expressed his acceptance of her. Following the termination of their employment contracts in Taiwan, the couple returned to the Philippines. They exchanged wedding vows on June 19, 1997, and subsequently moved to a rented residence in Caloocan City. Their marital relationship was marked by frequent arguments, often centered around Bebeco's past. Haneko, in the meantime, secured employment as an entertainer in Japan, falsely representing himself as single on his passport. After 2 years of no contact, Haneko informed Bebeco that he would not be returning and had found a new partner. Bebeco initiated legal proceedings by filing a petition with the regional trial court seeking the declaration of nullity of their marriage on the grounds of psychological incapacity. Will the action prosper? The answer is no. The action will not prosper because Bebico failed to provide sufficient evidence to declare Haneko psychologically incapacitated. The Supreme Court states that a petition for a declaration of nullity of marriage on the ground of psychological incapacity under Article 36 of the Family Code is limited to cases where there is a downright incapacity or inability to assume and fulfill the basic marital obligations, not a mere refusal, neglect, or difficulty, much less ill will on the part of the errant spouse. Such incapacity must be proven to exist prior to or at the time of the celebration of the marriage of the parties. Absent such clear and convincing evidence, the petition must be denied based on the case of Santos Macabanta versus Macabata. Again, Santos Macabata versus Macabata. Next question. In high school, Nuna and Oppa were sweethearts. Nuna became pregnant, leading her mother to persuade her to marry Oppa. Their marriage was officiated by Judge Braga of Iligan City RTC. Nuna covered the expenses for their wedding and child baptism, as Oppa was unemployed and unable to contribute. Nuna's mother moved in with the couple, which eventually strained their relationship. Nuna left their home and Oppa never visited or provided financial support for her and their child. Consequently, Nuna lost contact with Oppa after relocating to another town with her mother and child. In January 2010, Nuna filed a petition for the declaration of nullity of their marriage under Article 36 of the Family Code with the RTC of Tagaytay City. She alleged that Oppa was psychologically incapacitated to fulfill essential marital obligations. During the marriage, Oppa demonstrated a lack of understanding of his roles as a husband and father. He relied on his older sibling for support, spent considerable time and money on gambling and cockfights instead of caring for his family, and failed to attend the scheduled hearing. During the trial, Nuna testified and Dr. Oma diagnosed Oppa with narcissistic personality disorder, characterized by self-importance, antisocial traits, and dependency. Dr. Oma couldn't evaluate Oppa personally due to his non-cooperation. However, the court ruled that Nuna failed to prove that Oppa's inability to fulfill the marital obligation stemmed from an incurable pre-existing psychological illness. The court found Dr. Oma's report and testimony insufficient to establish the history and development of Oppa's alleged disorder or its impact on its marital responsibilities. Is the ruling of the court correct? Suggested answer. No, the ruling of the court is not correct because it relied solely on the expert testimony. As a rule, the Supreme Court established that expert testimony is not always mandatory as long as the totality of evidence is sufficient to sustain a finding of psychological incapacity. The totality of evidence must still be sufficient to prove the incapacity was grave, incurable, and existing prior to the time of the marriage. Take note that you have to remember the parameters given in the case of Tan and Dal. First, psychological incapacity must be shown to have been existing at the time of the celebration of the marriage. Second, that the cause was a durable aspect of one's personality structure, one that was formed prior to their marriage. Third, caused by a genuinely serious psychic cause. And fourth, it is proven by clear and convincing evidence. This case is based on the ruling on Pugoy Solidum versus Republic. Next question. Ganda has submitted a petition seeking a presumptive declaration of death for her spouse Pepito. During the trial, it was established that Pepito and Ganda were wed in Mandaue City on June 5, 2000. Several months later, around November 2005, Pepito departed without providing any information about his whereabouts. Ganda stated that she had no knowledge of the reason of Pepito's departure and mentioned that he had a cyst on his right jaw that was progressively worsening. Since Pepito's parents had already passed away, Ganda reached out to his only surviving relative, Lydia, via a letter hand-delivered by one of her witnesses, Marites. Lydia informed Ganda that she had no knowledge of Pepito's location. Ganda also inquired with their friends, but none reported having seen or heard from Pepito. Ganda genuinely believes that her husband is deceased, given that 6 years have elapsed without any information about his whereabouts. She initiated a petition with intention of remarriage. Will the case prosper? Suggested answer. No, the case will not prosper because Ganda was not able to establish the fact of a well-founded belief that Pepito was already dead. As a ruling of the Supreme Court, it stated that one of the requisites for a grant of petition for declaration of presumptive death under Article 41 of the Family Code is that the present spouse has a well-founded belief that the absentee spouse is dead. This requisite is met upon showing of proper and honest-to-goodness inquiries and efforts to ascertain not only the absent spouse's whereabouts, but also whether they are still alive or already dead. The mere fact that the spouse is absent is not enough to yield a presumption of his life or death based on the case of Republic versus Ponce Pilapil. Next question. The heirs of Barbie, referred to as heirs of Barbie in legal documents, have filed a complaint against Ken and Loveliness. The complaint seeks the execution of a deed of absolute sale for a 200 square meter area called the subject property and a transfer of title to the heirs of Barbie. Since 1955, Barbie and her heirs have occupied the subject property, which is part of the 1,417 square meter parcel previously owned by spouses Sachs and spouses Carps. In 1967, their property was sold to Ken. In 1985, Ken sold the subject property to Barbie under an agreement. It required Barbie to make full payment by the end of 1985, or else the agreement would be treated as a lease, with her payment considered as rent. Barbie made an initial payment of 2,000 pesos. The heirs of Barbie claim that Barbie fully paid the subject property before the death, as stated in an extrajudicial settlement. Ken agreed to this and received a check of 61,000 pesos. Over 61,000 pesos. However, Loveliness later demanded that the heirs of Barbie vacate the property, alleging that Barbie did not make the subsequent payments and all payments were rent. After Ken's death, Loveliness took his place in the proceedings. Despite demands, Ken refused to execute the sale deed, leading to the complaints for specific performance. The regional trial court ruled in favor of the heirs of Barbie, validating the sale agreement and treating it as a quieting of title case. Is the RTC correct in treating the case of specific performance to quiet the title of the case? Yes, the RTC is correct in treating the case of specific performance to quiet the title of the case because the purpose of the action is to remove any cloud on the title of the respondents. For an action to prosper, two indispensable requisites must concur. Namely, first, the plaintiff or complainant has a legal or equitable title to or interest in the property subject of the action. Second, the deed, claim, encumbrance, or proceeding claimed to be casting a cloud on his or her title must be shown to be in fact valid or inoperative. Again, Second, the deed claim encumbrance or proceeding claim to be casting a cloud on his or her title must be shown to be in fact invalid or inoperative despite its prima facie appearance of validity or legal efficacy. Based on the case of heirs of Marquez versus heirs of Hernandez. Question. Consent of the majority of the co-owners is needed prior to sale of a common property. True or false? The answer is false. Based on the case of Ulay versus Bustamante. Prior to partition, a sale of a definite portion of a common property requires the consent of all the co-owners because it operates to partition the land with respect to the co-owner selling his or her specific share therein. Look again. Question here is majority. What is required is all co-owners, consent of all co-owners, not just the majority, all co-owners. Okay? Take note of that. Next question. A property of approximately 2 hectares covered by OCT number P46114 was owned by Vegeta and Bulma, collectively known as the Vegetas. Currently, portions totaling around 16 hectares of his property are occupied by individuals including Piccolo Gohan, Android 18, and Trunks Goten, hereinafter referred as Piccolo et al., nephews and nieces of the Vegetas, namely Krillin, Yamcha, Tien Shinhan, Videl Pan, claim to be their legitimate heirs. They filed a petition to regain custody of OCT number P46114, alleging that Piccolo et al. Deceitfully acquired portions of the property over time, taking advantage of the Vegeta's ignorance and illiteracy. They asserted that a valid extrajudicial settlement of the estate, which includes the subject property, was signed by the legitimate heirs. Piccolo et al. Filed a motion to dismiss, asserting ownership through acquisitive prescription, citing possession of the respective portions for at least 30 to 50 years. They argued that the petitioners failed to assert their rights in a timely manner, invoking laches as a bar to recovery. Will the claim of Piccolo on laches prosper? The answer is no. The argument of Piccolo and his cohorts on laches will not prosper because there was no delay in asserting the complainant's rights. In a case decided by the Supreme Court, they said that laches does not imply that a case in court must be filed in order that it may not be successfully invoked. It merely requires delay in asserting the complainant's right after he had knowledge of the defendant's conduct and after he has an opportunity to sue. The essential elements of laches are: first, conduct on the part of the defendant or of one under whom he claims giving rise to the situation complained of. Second, delay in asserting the complainant's rights after he had knowledge of the defendant's conduct and after he has opportunity to sue. Third, lack of knowledge or notice on the part of the defendant that the complainant would assert the right on which he bases his suit. Fourth, injury or prejudice on the defendant. In the event relief is accorded to the complainant. Again, injury or prejudice to the defendant in the event relief is accorded to the complainant. Okay. Based on the case of Ende versus Roman Catholic Prelate of the Prelature Nullius of Cotabato Incorporated. Okay, next question. Harvey Specter, along with his legal team, has filed a complaint seeking reconveyance, cancellation, and quieting of title against Mike Cross and others. This legal action stems from the Daniel Hardman's sale of portions of Lot 71A PLS-D and Lot 71D PLS 631D to Harvey as a means to cover his medical bills. It is worth noting that at the time of the sale, the entire property did not possess an official title. However, it had undergone a survey in preparation for a patent application in Hardman's name. Unfortunately, this sale and survey were not recorded for Harvey's benefit. Subsequently, Mike Ross and his associate executed an extrajudicial settlement of the estate of deceased Daniel Hardman. This settlement included the sale of properties apportioned to Harvey, which remained unregistered at that time, through a free patent application and subsequent issuance of original certificate of title under the name heirs of Daniel Hardman, including the subject portion. Harvey sought to remove any ambiguity surrounding his title to the aforementioned portions. His goal is to ensure that his ownership remains undisturbed. In response, Mike Ross has countered the claims, asserting that no sale transpired between them. According to Mike Ross, Harvey provided financial assistance, and their legal proceedings, which resulted in the free patent and OCT, were conducted independently. Possession of the property was only granted to Harvey after the issuance of the OCT, which Mike Ross characterizes as an act of tolerance and a form of repayment for the financial assistance provided. Now all that facts. Question is, was there a contract of sale? Yes, there was a contract of sale because it was perfected by the mere consent of the parties. A contract of sale, whether oral or written, is classified as a consensual contract, which means that the sale is perfected by mere consent and no particular form is required for its validity. The issue of statute of frauds is of no application because it only affects the enforceability of the contract, not its validity. Remember, the question is, was there a valid contract of sale? Okay, this is the case of Pascual Purisima et al. Versus Macaria Purisima et al. A legal dispute centers on a property transaction involving the late Superman with conflicting claims. Superman had bought a property including a house from the Wayne couple, Batman and Catwoman. A title note mandated the National Housing Authority's approval for property disposal. The involved parties, Superman and the Waynes, executed several documents including a contract to sell, deed of absolute sale, and an agreement to purchase and sell. Afterward, the Waynes requested permission from Superman to remain on the property until they relocated, agreeing to pay a monthly rent of $3,500, which they never paid. They also pledged to secure the NHA's consent for the sale, but this did not happen. Superman paid them over $800,000 per receipts, and they paid to transfer the property title once they obtained the NHA's approval. They also borrowed the property's title, intending to cancel the mortgage. Due to the missing consent, Superman hadn't paid the full purchase price. He sent a written demand, but the Waynes did not comply. When Superman learned of a second sale to the Flash, he filed a complaint asserting that the sale was malicious. Is the rule on double sale applicable in this case? No, the rules of double sale are not applicable because there are multiple sellers present in this case, not multiple buyers. The provisions of Article 1544 of the Civil Code on double sale is not applicable. In order for the foregoing provision on double sale to apply, the following circumstances must occur. First, the two or more sales transaction in the issue must pertain to exactly the same subject matter and must be valid sales transactions. Second, the two or more buyers at odds over the rightful ownership of the property or the subject matter must each represent conflicting interests. Third, the two or more buyers at odds over the rightful ownership of the subject matter must each have bought from the same seller. Thus, the rule on double sale applies when the same thing is sold to multiple buyers by one seller, but not to sales of the same thing by multiple sellers, based on the case of heirs of Gonzalez versus spouses Basa. What is trust? A trust is the legal relationship between one person having an equitable ownership of property and another person owning the legal title to such property. The equitable ownership of the former entitling him to the performance of certain duties and exercise of certain powers over. Again, exercise of certain powers by the latter, based on the case of Daniel versus Magkaisa. What is an implied trust? An implied trust is created when a property is sold to one party but paid for by another for the purpose of having beneficial interest in the said property. An implied trust arises not from any presumed intention of the parties but by operation of law, in order to satisfy the demands of justice and equity and to protect against unfair dealing or downright fraud. The burden of proving the existence of a trust is on the party asserting its existence, and such proof must be clear and satisfactorily shown must satisfactorily show the existence of the trust and its elements. While implied trust may be proven by oral evidence, the evidence must be trustworthy and received by courts with extreme caution and should not be made to rest on loose, equivocal, or indefinite declarations. Trustworthy evidence is required because oral evidence can easily be fabricated. What is the doctrine of apparent opportunity? The doctrine of apparent opportunity, with special reference to banks, has long been recognized in this jurisdiction. Apparent authority is derived not merely from practice. Its existence may be ascertained through, first, the general manner in which the corporation holds out an officer or agent as having the power to act, or in other words, the apparent authority to act in general with which it clothes him. Second, the acquiescence in his acts of a particular nature with actual or constructive knowledge thereof within or beyond the scope of his ordinary powers. As a rule, the creditor's right to sue the surety is separate from the right to sue the principal or other sureties. Question: May the creditor's right to deprive the said surety of his property without due process of law? Again, may the creditor have the right to deprive the said surety of his property without due process of law? The answer is no. The right of the creditor to proceed against the surety refers to the right to sue the surety independently of the right to sue the principal or other sureties. By proceed, the law means to sue or to institute proceedings for collection or enforcement of the surety contract. However, the creditor's right to proceed against the surety does not give him any right to deprive the surety of his property without due process of law. It does not contemplate a situation where the creditor is allowed to take by force or without consent the property of the surety. Much like collecting from the principal debtor, the creditor may recover only through lawful means, from the case of spouses Henotiva versus BDO. Question: is personal notice to the mortgagor in an extrajudicial foreclosure proceeding necessary? Answer is no. It is well settled. Well settled is the rule that personal notice to the mortgagor is in an extrajudicial foreclosure proceeding is not necessary. Again, well settled is the rule that personal notice to the mortgagor in extrajudicial foreclosure proceedings is not necessary. Section 3 of Act number 3135 as amended by Act number 4118 requires only the posting of the notices of sale in 3 public places and the publication of that notice in a newspaper of general circulation. An exception to this rule is when the parties stipulate that personal notice is additionally required to be given to the mortgagor. Failure to abide by the general rule or its exception renders the foreclosure proceedings null and void. Last question. May a debtor who has paid a part of the debt ask for the proportionate extinguishment of the mortgage? The answer is no. Based on the case of Goldwell Property Tagaytay versus Metrobank, under Article 2089 of the Civil Code, a pledge or mortgage is indivisible, even though the debt may be divided among the successors in interest of the debtor or of the creditor. Based on this provision, the debtor cannot ask for the release of any portion of the mortgage property or of one or some of several lots mortgage unless and until the loan thus secured has been fully paid, notwithstanding the fact that there has been a partial fulfillment of the obligation. Hence, it is provided that a debtor who has paid a part of the debt cannot ask for the proportionate extinguishment of the mortgage, as long as the debt is not completely satisfied.